you very much. Thanks, Gavin. Okay, good morning, everybody, and thanks very much to Gavin for the invite to speak at this morning's event. I suppose by way of introduction, my name is Graham Nolan, and I'm the Consultancy Manager for Graphite HRM. So we're part of the Peninsula Group, and we're a HR consultancy and advice and support service as well. So I suppose as part of my role here today is to try and take us through some key HR, employment law, health and safety updates. So I'll be trying to give a general overview, hopefully try and make some common sense of it for everybody and have some key takeaways for people today. And in particular, I will spend a little bit of time focusing on the Miscellaneous Provisions Act 2018, which has come in and is now in place since the start of March. So we will kind of focus on that at the outset and try hopefully shed some light on that piece of legislation for you as employers, as business owners and as senior managers in your business to try and maybe remove some of the greyness around that piece of legislation. This is a big piece of legislation that is in place since the start of March. Okay, the Miscellaneous Provisions Act, the Employment Miscellaneous Provisions Act 2018 is now in place. Okay, previously we've been trying to get out there and explain to employers that this is coming down the line. Since the 4th of March, this is in place now. Okay, so this is now the standard for what I'm going to talk about here. It's in, and we need to be compliant, and we need to think about how can we get compliant or what steps we might need to do to make sure we're compliant. Importantly, the pieces of legislation I just touched on there, this doesn't get rid of any of them. This is in addition, okay, and it places additional burdens on the employer, okay? So I'm going to try break it down as best I can, but just it's interesting to see the question that was asked there in terms of how many people were aware of GDPR. We nearly had a full room, and how many people were aware of the Employment Miscellaneous Provisions Act, and it was considerably less than half, maybe a handful of people were aware of it. So it became law on the 4th of March 2019. It was actually signed into legislation in December by our president, but they gave a kind of a couple of months run-in into the start of March. But it will certainly have a significant impact on every employer in Ireland, okay? To what extent, it remains to be seen, but it will impact, and it's really, really important that you, I suppose, are conscious of it and that you have a think about it and hopefully take some guidance away from today's session to have a think about, is there an issue there? Do you need to rectify anything? How are you currently fixed from a compliance perspective in relation to your employment documentation? That's a really, really big area where this impacts. So just to put it in context, this landmark piece of legislation was described by our Minister, Regina Doherty, who brought the piece of legislation in as a once-in-a-generation reform of our labour market. That's how it was described in December, just before it was signed in, okay? And yet we're asking a room full of business owners, employers, senior managers, directors in businesses, how aware you are of it, and it's not out there. There hasn't been much communication done on it, okay? And yet it's being described as a once-in-a-generation reform of our labour market. So it's a really, really important piece of legislation. Why is it important for us, okay? So it impacts on all employers, regardless of size or industry. There's some different pieces of legislation that are coming down the line. The likes of our gender pay gap reporting has got quite a lot of attention recently. That's still a number of months away, and that isn't necessarily going to impact on every organisation because they're going to put limits on the size of organisation that's going to impact on for confidentiality reasons and so on. And they're going to drip feed that one in. Whereas this is a piece of legislation that has come in and will impact, doesn't have restrictions like that, so it does impact on every employer. Naturally enough, it's a piece of legislation. I've just talked about the onuses and the responsibilities these pieces of legislation place on employers. It increases penalties against employers, which I'll try to talk through this morning. It creates a need to ensure your recruitment process is proactive and robust. And I'll explain a little bit more around why it does that as we go throughout today's session. And really importantly then also, it brings in the need to ensure compliance with minimum payments. So for people who mightn't get the work that they need to be available for, there's certain minimum payments that are in now as well. So it's really, really key piece of legislation. So what does the Act say specifically? And I'm not going to bring the kind of legal jargon and legislative language that's used in it. I'm going to try break it down into some key points and key takeaways for today's session. And by doing that, we've identified 4 key core points that you really need to be aware of and need to have a think about and try and consider your business's position in relation to compliance, okay? So your basic terms of employment, crucial area, okay? Whether you're talking about a statement of main terms, your contract of employment, however you want to term it, It's really, really important area, okay? And it always has been. Currently, our legislation says that you need to have issued your employees with a contract within 8 weeks. So obviously from a best practice perspective, a lot of people will do the recruitment process and the contract situation may be sorted out in advance of somebody starting. These are the T's and C's, somebody accepts them, you get it signed up. I just talked about the challenges that are there for SMEs. That is not always possible, okay? It's not always going to be a workable solution. And so the legislation currently is you have 8 weeks to get that documentation signed up and issued to the employee, okay? That is still the case. That's still there, okay? So that hasn't been removed. So their full T's and C's still need to be issued to them in that period of time. However, in addition to that now, since the 4th of March, there is now criminal sanctions for employers who fail to give employees their 5 basic terms of employment within 5 days, okay? Criminal sanctions, okay? And I'll touch on that in terms of what those penalties can be as we go. The criminal sanction will be triggered if it's not issued within a month. So basically the reason I put that in there is because basically the employee has to have been in employment with it for a month to be able to take a claim, okay, against it. But the criminal sanction is in relation to 5 days. Okay, so you need to get 5 core terms, and I'm going to take you through what those 5 core terms are. That needs to be issued. So that's a key thing to take note of and be prepared and have a think about, are you prepared for that, or what can you do to get prepared for it? As I said, our existing laws remain unchanged still, okay? Require employers to provide the remainder of the terms of employment to the employees within the 2 months, within the 8 weeks. That's still there, okay? It's the 5 days is in addition. The 5 core terms, okay? Your full name of employer and employee is one, okay? Full name, employer, employee, okay? The second one, the address of the employer. The expected duration of the contract, okay? So whether it's fixed term, specific purpose, maybe it's a contract of indefinite duration or a permanent contract, whatever the expected duration of the contract is. The rate or method of calculating the pay, okay? And again, a key core basic term. That's the 4. And the 5th one, an important one, okay, and it'll carry through when I talk about it in terms of 0 hours as well. What the employer reasonably expects the normal length of the employee's working day and week will be. Okay, what do you expect their normal working day, their normal working week to be? They're the 5 core terms that now need to be issued within 5 days. Okay, so something to be aware of and be prepared for, and have a think about, how is your business in line to be compliant with this, or what steps might you need to take to get compliant with this, okay? And I will touch on some of those things that we can talk about once I've gone through the key points. Secondly, 0-hour contracts, okay? So this piece of legislation, this has been talked about for quite a bit, okay? And this piece of legislation prohibits the use of 0-hour contracts, except in certain circumstances, okay, which we'll talk through. But that's the whole idea behind it. To give a bit of background, this kind of goes back to a study that was conducted a number of years ago by the business school in UL. They were asked to do it to see how prevalent the issue with 0-hour contracts was, and was it something that needed to be addressed. So this piece of legislation has been a number of years in progress and in construction and in the pipeline, okay? And it's taken a long time. There was lots of amendments back and forth on it, changes, updates, before they finally settled on this. So the 0-hour contract piece, it prohibits the use of 0-hour contracts except in situations of genuine casual employment, okay? We don't necessarily have a definition of genuine casual employment, so you will need to consider the circumstance, is it genuine casual employment? And where they are essential to allow employers provide cover in emergency situations or to cover short-term absence. Okay, so it does prohibit it with that little caveat there as well. Okay, this, I suppose, will be particularly prevalent, we would suggest, in terms of the hotel, retail, and tourism industry. But it's going to have an impact on all employers. Okay, because there is an issue here around casual employment, 0 hours. Is it casual? Is it a 0-hour contract? What terminology are we using in our contracts? That's what it will come down to. And that's what you need to go back and take a look at. Okay, am I comfortable and confident that I know what terms are in my employees' contracts? Am I comfortable and confident that it is or it isn't a 0-hour contract, or that it is or isn't a casual contract? And if it is a casual contract, is it actually a casual employment situation whereby it's ad hoc, there's no guarantee, but also if that person isn't available, that's okay too. They're not expected to be available. These are all things now you'll need to consider, and in particular, it comes down to the terminology in your contract. Is it right? Does it very clearly protect the organisation, and is it compliant with this piece of legislation, and does it give the employee sufficient information as they need and as they're required under this piece of legislation? Okay. Third piece, minimum payment, has also come in. Okay. So a new minimum payment for employees who are not called into work on a certain week. So again, this is outside the casual piece. Okay, so if you're in casual employment and there isn't a guarantee of work, and similarly, there isn't an expectation that you need to be available for work, that's casual. Okay, but in terms of the 0 hour, we're not guaranteeing you hours, but you need to be available for work. Okay, and you need to be available for maybe a certain amount of hours per work. So for example, in a situation like this, if the contract was a 0 hour contract and you had 6 employees called into work, but you only had work for 3, those 3 people who you didn't have work for would now be entitled to a minimum payment as well for that time, okay? That they weren't in work or that they weren't needed to come to work. And that is 3 times the national minimum wage, okay? So that's the minimum payment that they would need to get, and that has now been introduced and is in again. So as you can see, this is kind of bringing me back to that point that we asked at the start in terms of how many people are aware of this. This is a key and important piece of legislation. Okay, and we need to get up to speed, and the first thing we'll need to be having a look at where we stand. Okay, what do we currently have in place? Are we protected? Are we compliant? Are we looking after our business? Do our employees know what their terms and conditions are? Or do we need to kind of have conversations around that and have a look and see what we need to do? So that's an important piece to be aware of as well. Okay, and then the next additional one, the last piece that we're going to look at in terms of our 4 core terms, are banded hours. Okay, so this was talked about an awful lot in terms of what's going to happen here. So this is a new right for employees that's added in as well, in addition to what we have, okay? And the idea here is to more accurately reflect the hours that they work, okay? And that's the intention behind this whole piece of legislation, okay? To give more protection and security to employees who are in these kind of more casual situations or less secure employment, I suppose, is the way it's termed. So the idea is to make sure that the contract more accurately reflects the hours that they work. There is a reference period has been put in for this, okay? So it's not picking a number out of the sky, which is important. Over a 12-month period in terms of their contractual hours. So if somebody now came to you as an employee to say, my contract says X amount of hours or doesn't say an amount of hours, but over the last 12 months, on average, I have worked 20 hours per week. You will need to go back and have a look to see and to be able to evidence, is that correct? And if so, they have an entitlement to go into a banded hours contract, okay? That will more accurately, is the wording, more accurately reflect the hours that they work, okay? So this is the kind of premise behind it, that the contract does reflect the hours of work. So the employee can claim increased hours, and it's the employer's responsibility to prove otherwise. There's an additional thing to keep in mind here with this that further emphasises the point. We would always, under our Organisation of Working Time Act piece of legislation, which I highlighted at the start of the session, there was always a requirement for us to be able to record and evidence the hours of work of our employees and the breaks that they were getting, and that they were getting their daily rest periods and so on. Okay, and we always needed that. It was always employers' responsibility to be able to evidence that. But similarly now, one of the key things that's going to come from this legislation is if an employee comes to you, again, it's the employer's responsibility to prove otherwise. So you're going to have to be able to go and have a look to see, well, actually, what hours has this person worked? And do I have record of that? To be able to say, well, actually, no. And it's not just because the employee asks they need to be put into the banded. An employer can absolutely have a look, review the information that they have, review the records they have of the hours of work, and there may well be certain situations that there was only during a particular period of time that it was extra, but actually over the 12-month reference period, the contract is still applicable and is still relevant and is still fine. But the onus is on the employer to make sure that they have that information available to be able to go back and respond in that way. Okay, so really, really important. The bands I think they start at 3 to 6, and then they go 6 to 11, 11 to 16, 16 to 21, 21 to 6, up in brackets like that, up to 36 and over. Okay, so that's the bands. They're very clearly defined in the legislation, and also they clearly define the reference period being 12 months. Okay, so that's what you will view it over.
Hours you're
hours. Yeah, sorry, yeah. So 3 to 6 hours, 6 to 11 hours, and that's then they're getting that banded hours contract to reflect that that's the hours in between that amount of 5, that's 6 to 11 hours, that's what that person will get every week. That's what their contractual entitlement will be, because that's on average what they worked over the last 12 months. Okay, so another key update that's come in as part of this piece of legislation. So that's kind of the key things we've identified as your 4 core items to take away from this piece of legislation. That basic terms, okay? So that 5 core terms, really, really important. The 0 hours contract, have a think about it. Do you have them in place? Are you comfortable or confident that you do or you don't? Do you need to check your terminology of your contracts to see, is it 0? Is it casual? And whichever it is that accurate? Or do I need to have a think about this and get some support or advice to see what is the best contract to make sure that I'm compliant? Similarly then, our minimum payment, okay, which will impact on if we have 0 hour contracts in place and people need to be available. And then the banded hours. If an employee does look and come to ask some questions around this, that we are comfortable and confident that we have the evidence to be able to kind of review it and have a look and go back and give information to them. And if we need to update it from there. Okay, so really, really important key terms. So some penalties. Okay, I wanted to focus on the key issues before the penalties. So there can be awards to employees, okay, similarly in terms of our WRC and so on, in terms of if people haven't been fairly compensated, there'll be awards to employees as well in terms of their payments. In addition to that though, the criminal sanction is there in terms of imprisonment for a period of up to 12 months. Okay, so a criminal sanction has come in with this piece of legislation. There was plenty of lobbying against that from employers' bodies. It's an extremely severe sanction. But it is included in this piece of legislation for a breach of the basic core terms. So that 5 core terms, that needs to be issued. That's key. This is where that criminal conviction can come in. And similarly, in addition to that potential imprisonment, it's up to a Class A fine of up to €5,000 for any breaches of that. There's anti-penalisation awards then of up to 2 years' salary. So that's an employee feels that they've been penalised for raising a concern, for raising an issue in relation to this, and they feel that they've been penalised. So there can be awards of up to 2 years' salary for issues like that. And similarly then fixed penalty notices based on inspections and if there is non-compliance or non-conformities. So it's a really, really important piece of legislation that we really need to have a think about. Is our business compliant and is it protected? Okay, that's really, really important. What do you need to do to prepare? I've touched on it quite a bit so far throughout the session, and one of the first things I would say is review. Have a think about, have a look at currently what you have in place. Okay, that's your starting point, because that's where you will decide how much of an impact this is going to have on you. Okay, it will have some impact, it definitely will. It's just to what end, and then what provisions you need to put in place to protect the business. One of the key things we would say is develop a core statement of terms. Okay, you develop your statement of core terms. So those 5 core terms that we talked about today at the start of the session, key, develop them. So even then, your full contract can come on the back of that. But if you have that, that's your 5 core terms in the 5 days. Okay, so it might be helpful to develop that and have that in place. Really importantly, reviewing your employment documentation in full. What do you have currently in place for your employees? Be prepared. I said it earlier in terms of prevention better than cure. It's better to try get ahead of this now. It's in, the legislation is here. Let's see what we can do and not wait for people to come to you or issues to be raised. An important one, like I just said for the banded hours, the requirement was always there from an Organisation and Working Time Act that we were able to evidence the hours of work that people were working, and they weren't in breach of the Organisation and Working Time and the max working week. They were getting their rest breaks during the day, their daily rest breaks. That's there. But now, in addition to that, you now have, I suppose, a business issue where an employee could come to you and say that the hours that they've been working aren't actually reflected in their contract and they want to go into a banded hours contract for X amount of hours. And you'll need to be able to go back and have a look, okay, well, can I have a look at what hours they've worked? And can I evidence otherwise? Or is that the case? Okay? So really important that you have a practical recording mechanism for hours, whatever that might be. Some people have swipe in, swipe out, clock in, clock out. Some have timesheets, sign in, sign out, whatever that might be. Make sure you have a practical record of that and something that can be reviewed. And ideally, you want to ensure that you can review those working hours easily and regularly. Keep on top of it is really, really important for this piece of legislation from a compliance perspective. Any questions on that so far? So you see, this is the outside of it, where if it's casual, that's not kind of where we're looking at from this. But this whole question of, is it genuine casual employment, will come into it then. As in that there's no expectation for you to be available for work. If you're not, that's okay. It's genuine casual. We have our core staff, but like you said, you used the term yourself, it's relief, it's in addition. That's that key thing. Is it genuine casual employment? For example, there are people in situations whereby their casual contract of employment, that's maybe what they have. But actually, you know, even during college, maybe say they work every Friday and Saturday. Okay, that's not genuine casual employment, because actually they work every Friday and Saturday over a period of time, and then they will be entitled to a contract to reflect that. So that's the key thing. So if somebody could still come and ask the question, and then if they can say, well, actually it's not genuine casual employment because I work every single week X amount of hours, then they will be entitled to a contract to reflect that. Yeah. That's a start in terms of having those 5 core terms, and I would do it from an employer. I would have that in place. That's a key thing. Have your statement of core terms. It doesn't remove making sure that they get the rest of their information as well, but that's compliant. But exactly like this gentleman said as well, if you have your contract and those 5 core terms there and you can get that done, that's fine. However you manage to do it, but that's one of the key things you need to think about. And if you think one of the first things I mentioned around how this impacts essentially on your recruitment and making sure you have a robust process in place for that, that's what we mean. It's from there you're thinking about, okay, how do we start this professional working relationship correct? Our employment relationship with this employee, let's make sure we're starting it on a compliant footing. Okay? Thank you.